Good evening, ladies and gentlemen. This is the third segment of the Saruman Show, hosted by your friend, Wally B, brought to you by King Queen Radio and Brooklyn Station. If you want to call for advertisements, they can be reached at 718-253-7273, or for a reading, you can contact Sister Dubong, spiritual advisor, at 718-253-7273. Quick disclaimer, the thoughts and views expressed on the Sovereign Mind Show are mine alone and in no way, shape, or form reflect on King Queen Radio itself. That being said, let's move forward. I want today's segment to be about the criminal justice system and how it tends to affect our community. Um, if you're from an area similar to mine, I'm sure you yourself or you certainly know someone that's been involved in the criminal justice system at some point in their life. Be it for an overt act they committed or could have been wrong identity for whatever the reason, especially as a young African American, you found yourself in that position before. And through many trials and tribulations, going through that, I had to make a lot of mistakes before I really figured things out. And one thing that always stuck out, one thing that was prevalent from past mistakes, even into the more current present, is that a lack of information tends to be one of the guiding factors in mass incarceration of blacks in this country, along with unlawful arrests. So the point of this show is I wanted to break down a little bit of legal language and some processes, just to acquaint the listener to how the process how it's supposed to go versus how it oftentimes goes for us. So that being said, I want to start off with first off, of the constitutional amendments, it's important to know all of them. However, as it stands with regard to criminal justice and just any kind of running with law enforcement, there are some that really stand out and that one should avail themselves of in order to better protect their rights. So the first being the First Amendment, the freedom of speech, press, assembly, and the right to petition government for redress of grievances. Now, we already knew there was, it's common knowledge as freedom of press, but I mean, how this applies to us directly is the fact that us filming using our cellular devices is covered by the First Amendment. So I'm sure you've seen videos on social media where there's a traffic stop and the person being stopped has a camera phone out and they're filming the entire incident. Now, if you also notice those very same videos, the officers never liked that. They hated it, in fact. So the question now becomes is, if the officers following the letter of the law and they're well in their legal rights to do that, to do what they're doing, it falls under their authoritative purview, then why would they have a problem being visually observed in doing such, especially when most of them are equipped with body cams themselves? The reason is that for a very long time, and it's coming to light, it's becoming to light in the last few years, but it's pretty much obvious now to anyone that has access to the internet, is that the way they're supposed to police and the way they actually do are two different things. They trample our constitutional civil rights left and right, and if you're ignorant of those rights, you're oftentimes going to fall victim. So if you find yourself in a situation and you had the opportunity to pull out your phone and record the situation, I advise you do so. Second part of that is why you were stopped in the first place. There's something called probable cause, which in layman's terms, a situation in which a reasonable mind would believe that a crime is currently been committed, has already been committed, or is about to be committed. That right there, once probable cause is established, it gives the officer a right to basically proceed with an investigation. Along with that goes with you identifying yourself, a possible search, and it could culminate into an arrest, depending upon, what facts come to bear during that investigation. But oftentimes, where the problem comes is these officers aren't properly establishing probable cause. I mean, there was a time when just smelling marijuana gave them the right to just, search you any which way they wanted to, and that wasn't right. And if it wasn't that, it was a person behaving suspiciously, which the Supreme Court ruling on this isn't cause to strip someone of their civil liberties, because you got to understand, if you're walking from point A to point B and officers stop you, you're detained. If you no longer have your freedom to walk away right there, one of your civil liberties have been taken, and that can't be done lightly, especially by someone acting under color of law. pretty much an agent of the state. So things have to be established before the process could even be started. And without doing that, they have little to no power over you. If we're being honest here, they don't have the right to ask you for your ID, ask you where you're going and what you're doing, unless they have reasonable suspicion that something is afoot, that a crime is being committed. So probable cause is very important. Now, your Fourth Amendment right. That's a right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure, and no warrant shall be issued without probable cause. Again, that term probable cause is very powerful, it's very wide-reaching. So what the Fourth Amendment pretty much says is that as a citizen, a taxpaying citizen, law-abiding taxpaying citizen, I have the rights to be secure in my person, my belongings, my papers, both private, public, or legal, and my residence. And along with that also goes your vehicle or anything that's locked that will require a key to unlock or a combination to unlock. I have a right to be secure in those faculties unless a valid warrant has been presented. And I implore anyone out there, when officers are accost you at your home, and I say accost specifically because it's oftentimes done in a very most disrespectful manner. They offer you none of the courtesies that you would believe a citizen should entail. Do not let them into your residence if they don't have a warrant. And that warrant has to directly articulate the places to be searched and the people and items to be seized. So before, don't just take a piece of paper from them and just let them come on in. Establish that the address is correct. And if it isn't, that search warrant isn't for you. A mistake on their part doesn't constitute you relinquishing a right on yours. So always, when possible, request a warrant, and upon getting one, read it very carefully to make sure everything adds up. And that goes for whether it's your residence or not. You know, I'm a firm believer if you don't live someplace, you shouldn't be answering the door anyway. You certainly don't let police in. If you're stopped at a traffic stop and officers ask you permission to search your car, lacking any reasonable reason to do so, always refuse. Always refuse. Even if you feel they may have a reason, refuse. Don't help them do their job because they're not trying to help you ultimately. So that's the fourth. Now your Fifth Amendment right is no person shall be deprived of life, liberty, or property without due process of law and protection against self-incrimination. That's a brief breakdown of it, but basically, in order for your liberty, which is your freedom to be taken, in order for your property, so your house, your car, any other belongings that they believe were acquired in ill-gotten manners, before any of that can be seized, taken from you, you as a citizen have a right to due process of the law, which means you're day in court pretty much. Anything other than that is tantamount to robbery, and it triggers a civil violation being done against you, and you now have a legal path in which to take the game to make yourself whole and to gain some kind of recompense. So that's very important. And also, whenever you heard the term plead the fifth, less is more when it comes to communicating with law enforcement. From the point of the arrest, there's nothing you need to be saying other than you want a lawyer. There are no deals that can be cut in the precinct. Those officers, they don't, other than the vague charge that they place against you, they have no control really for the rest of that legal proceeding once it goes to the DA's office and you're officially arrested. So talking to them will only basically bury you deeper because anything you say can be used against you in the court of law. And nowadays when things are recorded and filmed, you don't want to say something now that'll damage your case later on, whether you're innocent or guilty. Again, don't help them do their job. And know that if you're in the precinct and you're allowed to make a phone call, it's being recorded. It's being monitored. So be mindful of what you say, that call should be to your loved ones to get you counsel or to your counsel directly and nothing else. We're not speaking about the crime, the alleged crime, or anything of that nature. So that's the fifth. Sixth, also a very important one, the right to a fast and public trial by impartial jury, to be aware of criminal charges, to confront witnesses, and a right to legal representation. Basically, that expounds further on the due process aspect, which stipulates the exact process you go through in the legal system, from your arraignment, pre-trial hearings to trial, and depending upon the outcome of that, sentencing. There's a step-by-step guideline in which all these things are carried out, and any deviation from them can be favorable to the defendant because due process wasn't filed and that case can easily be dismissed. If you know the proper statutes to cite and you know how to actually move this forward via motions. These are things they don't teach you in school and they don't tell you about it when you're actually in court. And oftentimes you get stuck with a legal aid or a public defender who has a caseload of maybe 30 cases and their priority isn't you. So you're gonna have to do the homework yourself and basically fight for what's most important to you, which is your freedom. You know? Next thing I mentioned, traffic stops, probable cause, and arrest. Basically, in any criminal proceeding, when you really just peel away all the layers, there's only 8 steps to it. All right, there's initial arrest, where actually, you have to see it where this crime supposedly took place, or they show up at your house, at your place of employment due to a warrant, whatever the case may be. They find you, they identify you, they cuff you, they put you in a police car, they take you to the local precinct and begin the processing process. Booking. Normally, you're going to be in the precinct for anywhere from 5 to 12 hours, depending on the situation. And then from there, you got to go to the central bookings. Depending on where you're at, it's pretty much always the same thing. And there, you process your fingerprint, your photograph, and there's a warrant check done on you to see if you have any outstanding warrants in any other counties outside the one that you're currently that you've been arrested in. Afterwards is arraignment. That's when you're brought before a judge for the very first time and you're formally charged with a crime. Now, this part is very important because moving forward, whatever that charge is what you're going to wind up fighting. So it pays to pay very close attention. And oftentimes, they may use layman terms when speaking to you in the court, but you really want to get a handle on what penal code they're accusing you of violating, so that you can begin breaking that down and getting an understanding of exactly what you're being accused of. Therefore, you know how to defend yourself. A quick breakdown of a penal code is penal law section 265.01 subsection B. That is criminal possession of a firearm, Class C felony, right? Now that's a very vague way of saying that you have a gun. But in order for the state to make their case, they have to prove certain elements. They can't just throw a charge at you and think it's going to stick if the evidence doesn't match, doesn't complement the elements of the crime itself. And for that particular one, 265.01 subsection B, elements are to actually be in possession of a firearm knowingly. The weapon must be operable and it must be unregistered. Now there are degrees of weapons possession. That's like there are multiple degrees of most crimes. They normally go to first, second, and third, and first being the most severe, third being the least. But they all have those 3 elements. So if the firearm isn't actually on your person, nor any place that you would actually be under control of it, say in your car, which you have the keys, or in your home, which you have keys, not a place that the public itself can't access, only you, then they'll have a hard time making that case. But if you don't know how to fight these elements one by one and what motions to file in order to go for that case dismissal, then you'll fall victim by simply a lack of knowledge in a system that wasn't designed to help you, but only incarcerate you, to enslave you. So bear that in mind. Now, after arraignment, there's going to be a bail. They'll either set bail right then and there, or they'll remand you to the custody of the county, which in New York, you either go to probably Rikers Island or something like that. And then you'll have to maybe request bail. You have to request a bail hearing later. And now that's also covered under the 4th, where it says no excessive bail shall issue. And situations like if you have a person that lives in the projects, unemployed, but with criminal history, is it fair? Well, no, forget whether he has a criminal history. Is it fair to set $1 million bail on a person that with no income whatsoever? That's excessive bail. It's unconstitutional. So there have been actually changes to that law over the last few years that have remedied that somewhat, but it's still nonetheless a part of the process. After that, after you either set bail or you're remanded, that's now you're in a pre-trial phase of the proceedings. At this point, your lawyer, if you have one, will be basically putting in motions on the defense side. That's your side, to either dismiss the case, have the charge lowered, depending on the specifics of your case. But that's the time where motions are exchanged and where information is exchanged through a process called discovery. That's basically where one party requests from the other information pertaining to the case in preparation of trial, because that's the second to last step. After the pre-trial motions have been exhausted completely. Now you're ready for trial. This is two kinds of trial. You have bench trial, which is just by a judge, in which case he makes the ruling, or you have 12-man, trial by jury, where it's supposed to be a jury of your peers, people from your community. It's supposed to be diverse enough to where it isn't an all-white jury or all-male jury or all-female jury. It's supposed to be broken up to symbolize a community in which this case is taking place. That hasn't always been the case, but I mean, no system's perfect. But there had been situations where juror testimony has been thrown out because of bias shown based on demographics and ethnicity and things like that. So that's something that also I pay very close attention to and do some research on. And after trial, it's a simple matter of guilty or not guilty, or possibly a mistrial. If you are in fact found guilty, next will be sentencing, and for that you want to have knowledge of the sentencing guidelines. The factors that play a role in that, or whether or not you have past criminal history, the severity of the crime, and what the guidelines specifically say for that violation of that penal code. So these are things that you really have to research. I know it's strange to consider researching these things before you're actually in trouble, but I mean, if not even if you live a lifestyle in which you run the risk of incarceration, but if you do, you certainly need to pay attention to these things. But even if, like I said, you fall to a certain group of people that are at risk. And there was a study showing in 2003 that African American men are 8.5 times likely to be arrested than white people, and that for Hispanics that number is 5.2. So, and also, people of color make up 90% of those incarcerated in New York State. To have such a huge disparity between, race in an institution like that shows you that the law isn't being spread about equally. It couldn't possibly be because those numbers don't make sense. So, and even if they did, just the fact that the likelihood is that high means you want to be mentally prepared anyway. It's a sad truth, but it's a truth nonetheless. So we've gone through the 8 steps of a criminal proceeding. In other words, so it's arrest, booking, arraignment, bail, pretrial, trial, sentencing. It's something to give consideration to. And even if you're not a person that will run afoul of the law, hopefully that's the case. Like I said, we all know somebody in a situation like that, and I know from personal experience that it's harder to fight these things when you're in there than when you're out here. And there was a lot of times that I wish I had acquired certain knowledge and skills when I had the opportunity, rather than have to do it under the gun, where my freedom, my life really hung in the balance. So that's a little food for thought. And so that's that. Also, you'll notice you probably heard of something called legalese. Well, I mean, okay, well, yeah, it's a word, but basically what that speaks to is the fact that there are certain words in the English language that take on different meaning when applied to the law. And words themselves are very powerful. A word can evoke a thought, and enough thoughts will invoke action. Action becomes habit, and that brings about consequences. Words are pretty much the seed of almost everything. The only thing that precedes that is thought. Thought, words, actions, and there's often races from there. The reason I bring up words is because, well, of one specifically, the word minority. And people of color over the years have gotten very comfortable referring to themselves and people in their ethnic group and others of color as minorities. And I never really gave it much thought other than that's, the reference that was made, and I just, pretty much ran with it until one day I'm in a law library setting, and I'm, going through Black's Law Dictionary. I was looking for something totally different, but I found myself in the M's, and I came across the word majority. Now, if you asked me what the word majority meant prior to that, I would have said, it's the greater number of something else. Like, a majority of 10 would be like, let's say 7, with 3 remaining. The larger of the whole. That's majority. But the legal definition of majority is actually completely different. It's defined as full age, the age at which, or the capacity by which, by law, a person is entitled to the management of his own affairs and to the enjoyment of civic rights. The opposite of minority. It actually says that in a legal definition. And what that breaks down is a person that's a majority is someone that's mentally competent and capable to manage their life and express and enjoy their civil liberties, which are the fundamental rights that we all have to live and function in our society. So if the group that can exercise those rights are referred to as a majority, then would it be safe to say that the opposite of that, which would be minority, are people that aren't competent, aren't responsible to manage their lives or make proper use of their civil liberties? So I just think the implications there are very, well, pretty much obvious. Again, if you call yourself something, refer to yourself and your as something for such a period of time, it starts to take on a certain kind of reality for you. And again, words are very important. They be used as weapons more often in history than I can't mention. I mean, even in our everyday lives, just the way people react to you, your words and the way you react to theirs is a very unique and very real thing. And it can alter a situation for the better or for the worse. Words are very important, especially the ones we internalize. So I just wouldn't refer to myself as a minority anymore after learning that. And I don't think anyone out there who falls into whatever group that was considered a minority, I don't think anyone should use that word. No. Especially now that you understand exactly the system that can do you the most damage, what they consider that to be. So that's something to pay very close attention to. All right. Also, in a side conversation regarding the law, it came to my attention that a friend of mine had a bad run-in with some officers, and he wanted to make a complaint. He went to the precinct that the cop, worked out of, and was asked to make a complaint. It was given a runaround. Long story short, he was not able to make his complaint, and he expressed that how unfair it was that civilians had no ability to complain about an officer short of a lawsuit. And I told him that's wrong. Actually, the problem was you went right to the headquarters of the offending party, amongst all his allies and his supporters and his enablers. There's no way they were gonna let you harm their coworker, their brother in arms, if they had a say in it. And because of the way you went about it, then they felt they could get over on you, which is oftentimes what they do. There's an organization called the Civilian Complaint Review Board. It's located at 100 Church Street, 10th floor, New York, 1007. Call them via 311 or 1-800-341-2272. And you can also look them up online and file a complaint online. You don't even have to leave your home. You contact them via phone, in person, or online. You have the information you need. You have the officer's name, number. Hopefully you can get that information. The precinct they operate out of, the date and time of the incident, and a breakdown of what took place exactly. If you have any supporting papers such as medical records or property vouchers for something that was taken from you that was never returned, you want to upload those also to bolster your case. And you're gonna want to do that prior to suing anyway, because to question an administrative decision, which is done via Article 78, you have to exhaust all administrative remedies, which is the complaint process. So that's definitely going to be an element of it. I've seen lawsuits fail because they didn't exhaust that first remedy. So, and all this, and mind you, don't sit on the situation. If it happens Monday, if you're physically able to, you should be making this complaint Tuesday. Don't let it get old, because they're not going to take their time when it comes to destroying you. So you have to be just as fast, just as speedy when it comes to defending yourself. All right. So also, I think I spoke upon this, but I'll go back to it because I see I made the note. Once arrested, make no statements. Just request legal counsel and begin to think. Thinking is where you at right then and there, what took place prior, the reason they're positive, they're locking you up, what they think you did versus what actually, all these things you want to organize. So when you finally do speak to your counsel, they can give you both the best possible advice, and also, depending on where the situation goes, hopefully you're free. But if not, you have to immediately start your research process and basically your battle plan on how to beat the case. So that right there should be no verbal communication with law enforcement after that point at all. Everything should be internal. How are you going to get yourself out of that situation? By using the law at your disposal. Oh, also, be wary of this if you find yourself in a precinct. It's something that I've noticed they began doing over the last few years. See, because of the smartphone, most people don't know numbers by heart. That's just how it is, unfortunately. So they'll say, unlock your phone to get the number you need, and we'll give you a phone call. But they never give you the phone call with your phone. They have you unlock your phone, get the number, and use their phone, which they're recording on, and now they have your unlocked phone. And I have you know they go through it without a warrant. Find out what's in there. If something in there can be used against you, they'll lock it, and somehow or another they'll retrieve the warrant later. But that's under ill-gotten gains because you had the right to go through it in the first place. It's very common, so be on the lookout for that. If you carry a wallet, have your important numbers written down. Once you're in that precinct, there's no reason for you to unlock your phone. If they need to go through your phone, they'll need a warrant for that. So don't willingly ever do that when in a precinct. All right. Moving right along. See what we got here. Oh, the 3 types of police abuse of authority. Because especially when there's this adversarial relationship that we have with them. And by that, I mean, not even just the people of color, but people, period. You know, when you have people that have the license to carry firearms and discharge it with fatal intent, and they don't feel they have to follow the rules that they were, hired to enforce, then that's a very dangerous situation to be in, and everyone's in jeopardy. But that being the case, not every bad encounter with a police officer constitutes an abuse of power or police misconduct. It could just be that they're an asshole. That happens. However, when in doubt, know this: there are 3 major types of police abuse of conduct. 1, false arrest from illegal search and seizures. Now, that arrest could be retaliation for a comment made, or just for whatever reason they conjure up in their minds, or the fruit from a poison tree. If they search your property without permission, without a warrant, and they do turn up what they consider to be contraband or an illegal item, for them to make that arrest afterwards is actually unconstitutional. That case can be thrown out later if the proper motions are put in place. If you could prove that the evidence is ill-gotten, it came from a warrantless search. If you could prove that, then it's very possible, very likely, in fact, that you can have that case dismissed. But again, this comes with being cognizant, doing your homework, and strategizing. The second one, excessive or unreasonable force. It's probably one of the biggest things that law enforcement is accused of. And nowadays, with the the invention of the camera phone, we can actually see live footage of it taking place on a mass scale, so that we weren't able to do before. What could constitute excessive force? Any striking or any kind of mishandling after the person is handcuffed. The handcuffs were designed to immobilize the hands, which will basically render a person defenseless and thus not a threat to themselves or officers. Once those cuffs are applied, there is no reason for them to apply any more force to you. Oftentimes, once the cuffs go on, the real violence starts. I've been a victim of that myself. Now, there's excessive and there's unreasonable. A traffic stop where a person's going 5 miles over the limit, that doesn't call for them to be pulled out of the car, slammed on the hood, and cuffed. Even only to be let go a few minutes later with a warning. That right there, your rights are violated, constitutional, and you should basically, certainly, in fact, achieve some kind of redress for that. And the third is misuse of position of power. That could be translated in a few ways, but I'll give you an example. You have a police officer walks to an eating establishment and feels that he should be given a discount or not have to pay at all. You see that often. And if that isn't done, then the officer makes trouble for them. This is them hiding behind their badge and using it to gain perks that otherwise wouldn't be available to them or any other citizen. It's them using the power, which is great power when you think about it. I mean, they have the right to carry a firearm in especially New York, a very zero tolerance firearm state. And also they have something called qualified immunity, which protects certain government or city or state officials from prosecution for, as a matter of fact, let me get you the exact wording. Qualified immunity, a type of legal immunity that protects a government official from lawsuits alleging that the official violated a plaintiff's rights. Only allows suits where officials violate a clearly established statutory or constitutional right. This applies to police officers, judges, district attorneys, and what it means is they have a very high ceiling of what they can get away with. And when they are charged, much less convicted, it's only if it's a blatant violation of the law. You can think of, as a good example, you can think of the George Floyd situation. You have 8 minutes of footage of a police officer, now ex-police officer, kneeling on the neck of a cuffed prisoner for 8 minutes. So that right there is, there was no way that could have been cleaned up in called, something he'll do in the course of his duty. It was blatantly wrong. But I mean, to have to go through such extremes to get a conviction is, I mean, it's a day in which we live. It's all you have to do is Google. There's hundreds of cases where officers have discharged their firearms at a civilian with a fatal outcome, and they were maybe placed on administrative duty for about 30 days, and now they're back on the street with their gun because their favorite cliche, I was a fear of my life, thought they were going for a weapon. Now, the problem I always had with this fear for their life situation is I believe it's the civilian, the one whom they're approaching that should be in fear for their life. I mean, let's look at the stats. The officer has a bulletproof vest. He has body armor, which means he can withstand close arms combat, right? So they also have a firearm with 2 extra clips of ammunition. So if each one holds 15 plus, plus the one that's in there, that's about 45 rounds of ammunition. Plus they have pepper spray, tasers. They have a radio with which you can call tremendous amounts of backup. They have a shotgun in their trunk in most cases. So what are you afraid of? Not to mention the training they're supposed to go through prior to becoming a police officer, some of which involves hand-to-hand combat, calisthenics, things that make them physically strong enough to deal with whatever threat they may encounter while doing their job, protecting our liberties, what they're supposed to be doing, rather. Not what they do, but what they're supposed to do. So when I see that, and I actually saw one video where the victim was actually an older white woman. Now, I don't know what she was doing in that car, but this officer saw fit to draw his firearm and discharge it 8 times into her body, killing her. And his excuse was he was in fear for his life. No gun was ever recovered from inside that car. And to my knowledge, that officer wasn't charged. Now, she was an older woman. I think the story that was told was that she went to go turn the volume down or the radio was playing, she couldn't hear the officer. But her making that gesture placed him in such fear of his life that he felt that he had to shoot this older lady 8 times. And, those are the people that are supposed to be, keeping law and order. So that's some food for thought. I believe any transgression from them, any encounter that you're able to walk away from and they're in the wrong, you file a complaint and you sue them. Only when that happens will the request to do away or modify qualified immunity actually be taken seriously, because the city and the state, they're gonna get tired of losing all this money to lawsuits with these guys with these people in uniform running around with knowing that they can do these things with no legal consequence whatsoever. 9 times out of 10, that's a very dangerous element to have, prevalent in our neighborhoods. And many people have paid the price for that. So that's something that us as a citizenry really need to come together and do. I know it might seem like I'm anti-police. It's not that. I'm anti not doing your job properly. Because a lot of people say, they hate police, or they would like to see a world without them. I don't think you do, because then there'll be total chaos. Right now, it's at least controlled chaos. But the problem aren't law enforcement as a whole, but the few bad actors that go unchecked by their coworkers and are protected by a very strong union, qualified immunity, and a criminal justice system that sees them as a necessary evil, rather than actually upholding the laws and the rights of the citizens themselves. So that's something that really needs to be addressed. Okay, see what else we got here. Oh, discovery. You would think discovery when you find something, but the legal definition of discovery is a pretrial device that can be used by one party to obtain facts and info about the case to assist in preparation of trial. I know I touched upon discovery earlier, but I want to go back over it only for one reason. Prior to about maybe 15 years ago, a lot of defenders, especially those that didn't have private counsel, the ones that were depending on public defenders and legal aids, by the time when they were forced to trial, when whatever they were being offered as a plea deal was simply too steep, will trial seemed like the only option. By the time they actually made the trial, they only had about 30% of their discovery, and that means the actual evidence that would be brought to bear in that trial, they're only knowledgeable of 30% of it. Mostly the arrest report, any medical records, things that are easily obtainable that he probably had from the very beginning. But as far as maybe witness statements, any crime scene footage, any recordings, 911 call, the things of that nature, things that can actually assist in a defendant's strategy, those things were always withheld right before trial. And the law was changed not too many years back, or modified rather, where prior to trial, a lot more of this, the discovery has to completely be divulged to the defense prior to trial. And the only case in which something is withheld is a witness, in which case it may be a safety concern, but even knowledge of that witness will have to be made known to the defendant. Also, what they're saying, their actual identity will come out at trial for safety reasons. They won't divulge it prior to that, but that is the only thing to be withheld. Anything else that the prosecution has to hurt you, you should, and by law, have to have access to in order to help build your case and defend yourself. So that's very important. If you're fighting a case and you find yourself having to ask your lawyer more than once for documents that you know exist, accusatory instrument, any kind of record, statements, things like that, crime scene pictures, if you know they exist and that the prosecution has them, if your lawyer can't access these things for you, then you need to look at find new counsel. And definitely raise these things in court. You notice when you're in a courtroom, there's a person typing continuously. They type it a kind of shorthand. They call it a stenographer. Basically, they keep a live action, real-time recording of what's going on in the courtroom at that time. Everything uttered is supposed to be taken down for later on when you want to get the trial minutes. So I say that to say this. If there's a lot of times you may have a problem, something that you want to bring to the court's attention, and speaking through your lawyer, they won't make that move for you. They won't speak for you. Then in a case like that, you speak for yourself. You ask permission to address the court. They're going to request that you talk to your lawyer, at which time you tell them you've repeatedly spoken to your lawyer about a certain situation that you would like on record. While you're doing this, though, keep an eye on the stenographer. If he or she stops typing, make a verbal note of that and request that she continues. Because a lot of times that's a little trick they play to keep certain things off record. There are little signals that the judge can give the stenographer to stop typing. I don't know if they'll do it for a lawyer or a DA, but I know for a fact the judge has a certain degree of control over that. But once it's been raised and attention has been brought to it, they're compelled to continue. At which point, that's when you make the point that you want on record, and it might be something that you'll need later on for appeal purposes. So always use your voice in that courtroom. If you have a good lawyer that's fighting for you, and again, you only know they're good and they're fighting is if you're following the process yourself, if you're doing the research and your homework yourself, because otherwise they can be put on a very good but useless show. It's something that sounds good, but they're not actually getting anything done for you. So once you know the process, the steps they're supposed to be taking, you'll know whether or not they're actually taking those steps. So always pay close attention. And also, if you're not in the situation, I hope you never find yourself in the situation. But if you know someone that is, pass on as much as information as possible. You can do a lot of good. Let's see. What else we got here? We spoke on the arrest numbers, not really the incarcerated numbers. As of March 31st, 2023, New York State had 31,659 incarcerated individuals, and that's a 4% hike from 2022. The numbers for this year aren't available yet because the year's still ongoing, but hopefully it's gone down. Now, I already told you that blacks, 8.5% more likely to get locked up than whites, but in the actual prison system, and this is from the Federal Division of Prisons, the racial breakdown is blacks 52%, Hispanics 26%, and whites 20%. There's a disproportionate mass incarceration of people of color in this country, and it's definitely something to be addressed, especially since a lot of these crimes are nonviolent. A lot of them are parole violations, things like that, things that one shouldn't actually be incarcerated for. But again, you build these prisons, there are towns in upstate New York. I'll give you one, for example. Clinton Correctional Facility is located in Dannemora County, upstate New York. That prison is the only thing going in that town. If that prison were to die, were to stop, were to shut down, was to close its doors forever, no one incarcerated there, it's just gone. That town will dwindle and fade away inside of a year. It'll become a ghost town. So there's a financial incentive for those people to keep that prison going. And not to mention the fact of, the textiles plant, the things they actually produce that are sold for profit. And the individuals making these things, be it, depending on where you're at upstate, you could be making anywhere from manhole covers to license plates to garments to school desks, things like that. The actual laborers, which are incarcerated individuals, they only pay anywhere from 16 to 27 cents an hour. Whereas if you pay the actual person in the free world that same wage, you'd be paying them certainly above minimum wage. But even if it were just minimum wage, that's still light years better than what this convict is being paid for. Now, there's one thing to have your liberty taken, have to do time, depending on if that was a sentence that you agreed to, or if you lost at trial. That simply is what it is. But I mean, where is it written that you have to perform labor at slave wages? And by the way, you'll be infracted and placed in a special housing unit, which is the box if you refuse a work detail. So yeah, they force you to work in there for pennies. So when you consider that, and there's a DMV program also where if you're in a certain facility and your disciplinary record looks good, you actually work for the DMV while in prison. So a lot of times you might call DMV and think you're talking to somebody that's in the free world. No, they're actually in prison. And again, they make about maybe 58 cents an hour, which in there is a good job by their standards. But out here, it's a joke. It's laughable. And I mean, when you're in such a down position in there, that might be seen as a benefit. But when you're from the outside looking in, you can see the exploitation. And I think it's wrong. And I'm a huge advocate of prison workers being paid the wage that their free counterparts would make. Other than that, or don't force them to labor. They're there because their freedom has been taken based on a criminal conviction. All they have to do is serve that time, possibly participate in programs. They don't have to work for slave wages. So that's something I wanted to touch upon. And once again, this is the Sovereign Mind Show, brought to you by King Queen Radio and Brooklyn Station. If you want to call for some advertisement, we can be reached at 718-253-7273. Once again, at 718-253-7273. Or perhaps let us talk to Sister Dubon for a reading, spiritual advisor. Can be reached at the same number, 718-253-7273. Or if you'd like to call in, maybe talk to me, I can answer a few questions possibly. I could be reached at 718-676-0820. Again, that's 718-676-0820 or 718-253-4239. Once again, 718-253-4239. So just to wrap up this last segment, because again, it's a subject very near and dear to my heart, because taking a person's freedom is about a few cents below taking their life, because you're not just damaging one person, you're damaging anyone in that person supported, anyone that loved that person, anyone who that person may have played a role in someone's life. This is a parent we're talking about. This is a mother. This is a father. This is somebody's son or daughter. And if a crime was actually committed and the state acted in good faith and a sentence was passed, that's understandable. We live in a society where we want people to feel safe and secure. So there has to be punishment meted out for certain violations of our laws. That's what makes a society a society. But when that power is misused, or when it's only applied to some over others, that represents a huge miscarriage of justice, and it's something that should be addressed. Because don't believe for 1 second that every person incarcerated belongs in there. That isn't the case. A lot do, but a lot don't also. And a lot of times their voices go unheard because no one's advocating for them, or they lack the information and education needed to actually pursue it on their own. So I advise anyone that has someone in that situation, if you're able to contact them, tell them to get in that law library and study. And even if there's nothing they can do to better their current situation, it's possible to acquire knowledge in there that can be very beneficial financially, economically out here. There's work for law clerks, paralegals, things of that nature. Law officers, if you know how to research law, shepherdize, draft documents, things of that nature, that's very marketable. You can learn while you're in there, come out here, get the proper certifications, and you actually have a career path that, although it was born from a very negative place, you turn it into something positive. It's not many opportunities in life in which you get to do that. And of all the many programs that they do offer in there, most of which look good only on paper, they're very outdated. The legal research program is possibly the best one because all the information is current and it's relevant to the situation. In the past, I've made mistakes and I found myself in situations like this, and I've always worked in the law library. I got my legal research certificate both for the state and the city during that circumstance, and it not only allowed me to help myself but also help others. Um, the first time that I actually knew that it was a skill that I had was I was on Rikers in what building was that? OBCC. I was working in the law library, and this guy, forget his name, he used to come in and basically just hang out with the fellas, whatever. Just basically socialize. One day, none of his friends came in and said he was there just by himself. So I took the opportunity to ask him, how's your case going? You need any help? He said, nah, I'm just locked up for some body stuff. That's how he worded it. He actually said shit, but he said some body shit. So I've never heard it referred to like that before. You either locked up for a murder or manslaughter, you say it that way. The way he said it made me ask a few questions, and come to find out, he was locked up for what was that? Like class D felony. Basically, it's a felony that one step below that is a class A misdemeanor, but basically, it was tampering with a cadaver. Which and once you plead, the level of the charge drops. So in essence, he'd be pleading if he pleads out, he would have pled to a misdemeanor. He could have gotten more than a county year for that charge. Do you know how long he was locked up though? 18 months for something that once dropped would have been an A misdemeanor, and even if convicted on the top count, he would have been locked up for 18 months for it. So upon further questioning, law enforcement was under the impression that he knew who killed the guy. And their plan was to basically kidnap and torture him by incarceration until he informed on his friend. So the first thing I did once he told me this was I told him that if the prosecution isn't trial ready within a certain amount of time, the case is to be dismissed. The defense can file a motion to dismiss. But the one catch that is any adjournment, the time has to be, I believe it's like 180 days. But all that time has to be attributable to the prosecution, which means, let's say I'm locked up 180 days and my lawyer puts in a motion on my behalf. And it takes 30 days for that motion to be heard and basically ruled upon. That 30 days is on the defense and not the prosecution. Therefore, that 30 days wouldn't count in 180 days. So the first thing I asked was a calendar roll, which is basically a readout of every court date from the very first arraignment all the way to the present day. And it shows you exactly what was done on that day. Based on what was done on that day, you can see where the adjournment came from. It's either the defense asking for more time for XYZ or the prosecution requesting the adjournment. Because all of this adjournment, they're not trial ready, because automatically they'll start that process. So upon me getting his calendar roll, I saw that all that time, no defense motions were put on his behalf. So all that time was attributed to the prosecution. So all right. So filed a 30-30, which basically means they had to dismiss the case or be trial ready like immediately, right then and there. So I drafted a motion for him, gave it to him, went to court, came back. He says lawyer wouldn't submit the motion. So once I found out his next court date, I basically made a script for him and told him exactly what to say in open court and that he could submit it himself. I never saw him again after that day. But what did happen was this. While I was, going to chow, going to eat, I got a message to somebody that he basically said thinking he was home. And he cashed at me $500. It was right then and there that I realized I had a skill for it. And the fact that it wasn't just a job I was doing, I was passionate about it. And I felt the outrage that he didn't even know to feel at the time when this was being done to him. He thought it was perfectly normal to be locked up without going to trial for 18 months in a county jail. Makes no sense. It's not due process. It's a form of torture by prison. Once he understood that, once he saw the letter of the law, what it said in relation to his situation, he was then outraged. But I was outraged immediately because, when you have a system that's as well funded and well organized as a criminal justice system, you shouldn't have to cheat and cut corners. I mean, you're going up against the average Joe. The average Joe citizen knows little to nothing about law. So, I mean, it's like, what's that? Pistol with a blind kid. Basically, you're taking advantage of someone else's ignorance, them not knowing something. And I think that's wrong and needs to be challenged more. So once that happened, then I was highly motivated to pursue my studies even further. went so far as to actually file a 43 1983, a 42 USC 1983 against a sergeant in one of these upstate prisons for violating my civil rights, and I actually won. It took me a long time to prep that motion, a lot of research. I got once it was actually filed, I was in the facility of the officer I was suing. So things got a little bit sketchy for me. But one thing that you always going to put into a lawsuit when you're suing, especially in that situation, is something called a caveat. It's CAVEAT. Basically, it's a warning to the judge saying the kind of retaliation that you expect from you exercising your civil right. So how that went was I told the judge in the motion, now it's a matter of public record, that as a result of me filing this motion, this is a lawsuit, I'm going to be assaulted by officers. I'm going to be searched and have contraband placed on me. I'm going to be given a false drug positive, something along that line, so that I'll be taken out of general population and placed in a special housing unit, which is solitary confinement. The way that now you may just think, oh, so where's they gonna do what they want anyway? Here's the thing: I can't predict the future, and the courts don't acknowledge that ability at all. So if I tell them they're gonna beat me up for filing this lawsuit, and then afterwards I show medical records and an incident report that I was assaulted in this prison after I filed this motion, then they pretty much made the case for me, and I'll be something else admitted added to my lawsuit because because they know that once you put that in the motion, they're pretty much hands off at that point. They weren't even searching my living quarters after that. Why? They were afraid of bolstering my lawsuit and basically hurting themselves. So as such, one paragraph on a sheet of paper was actually able to protect me while I was in there and allow me to pursue my civil liberties. And I'm defending myself against a tyrannical and just super unfair system. So that's something to keep in mind. Everything must be documented, put on paper. Always have duplicates. Always have a backup. You know, if you're in there, you got your paperwork. One of the main things they want to do is lose your paperwork while you're in transit or something, as a means of slowing you down or hurting your case. Always make copies of things and send them to a trusted person, so that you always have access to them when you need them. So that might wrap it for the criminal justice aspect of this. Again, my last show was about information, and that's all this is too. That's the purpose of this platform, this forum, is the free exchange of ideas and information. I feel if I could reach one person with this broadcast and prevent them from going through something that I went through or worse, then I've successfully done my job. And with the way things are today, we don't have to resort to crime anymore to create revenue streams. I mean, look at this for example. As long as you got a camera, Wi-Fi, internet access, you can monetize your ability. You could produce something, be it content, be it a product, be it a service that could actually gain you the things you need in this world without having to resort to, let's say, any form of crime. But that's not the only reason you'll get locked up. You could be perfectly innocent, on your way from work, minding your own business, and you come across these people, and at that point, it's a very precarious situation because things can either go back to normal after, or your life might be completely irreversibly altered, all because of you're encountering with these people, whether or not they feel like doing their job properly or not. That's something and when that potential is out there, I believe that due diligence is required. You have to do your homework because what they say, it's not a legal maxim, by the way. It's just a saying. It probably came from a book or something, but ignorance of the law is no excuse. What they mean by that is, if you don't know something is supposed to take place a certain way in that courtroom, and as a result, you lose your freedom, well, then they say, oh, boo-hoo, it's not all them. You should have known better. Your lawyer should have been better. Now, if such a decision causes you to lose 8 years of your life, 8 years away from your family, 8 years away from the free world, just the effect that it has on a person is just monstrous. And we talk a situation where the person might have been innocent, or they could have been eligible for a shorter sentence, but because they were ignorant of the law, they had to suffer such a steep penalty. I think that's wrong. And us as a people, we need to use our collective voice and use all this knowledge that we have at our disposal to actually make the necessary changes. And that happens when the people out here start bringing these people to task, holding them accountable. If I'm walking down the street and I see police misconduct, guess what? I'm filming. And also, the victim of the police misconduct doesn't have to be the one to file the complaint with the Civilian Complaint Review Board. A bystander could do it on behalf of another. I've actually had that done to me before. When I was a teenager, police beat me up really bad, and this little Jewish lady filed a report on my behalf with the Civilian Complaint Review Board. And the short version is, when I got it, I wound up getting a check because of that. And when I found out who filed it, I tried. It was a neighborhood I'm familiar with, so I tried to track her down and tell her thank you, but she had passed away when I was locked up. So that gave me a lot to think about. And I mean, even outside the whole criminal justice aspect, the fact that this woman, who from a ethnic standpoint is so different, from a demographic standpoint, so different than me, saw the misconduct perpetrated against me by them and stepped in when a lot of people wouldn't have. That struck a chord with me, and it means that you don't have to know a person or be like a person to stand up for what's right. You just have to get out there and do it. She didn't get anything out of doing that, but she saw an injustice and she stood up and did something, and that right there motivated me to, if I have the opportunity, I'm going to do the same thing. Because it's an uphill battle with them on the best of days, so we need all the help we can get. Now, there are a lot of things going on in this world, but I mean, you could name any kind of major thing going on right now. Just look at your local news feed. There are very few situations, a few entities that if your encounter with them goes south, you can wind up dead. But with law enforcement, it's very much a reality. So I believe, especially if you fall into one of the, I will call them endangered groups. I'm one of those. You need to know exactly. You need to be prepared and armed with the knowledge of what to do when you find yourself in a situation like that, how best to proceed. Because a mistake in a circumstance like that can produce long-lasting negative outcomes, or possibly the end of your life or that of a loved one. And nobody wants that, other than them perhaps, because they're the ones doing it. But I mean, from my standpoint, it's bad enough that you might in an inner city or urban environment, you might run the risk of falling victim to some kind of violent crime, but you shouldn't have to live in fear of the people that's supposed to protect you from criminals and who are supposed to enforce the laws that keep us all safe. Once you fear them, then I mean, you're literally living in a constant state of fear, and there's no way to run a country. There's no way to live your life, and that right there, it creates a residual effect that gets passed down from generation to generation, and it's a poison. It's tantamount to a cancer. It's one of the main reasons that us as Black people don't trust government, don't trust establishments, period, because the letter of the law says one thing, the conduct says another. And after a while, it becomes blatantly clear that these institutions were not initially put in place to safeguard us, but yet they protect us nonetheless. But the actors, the agents that are supposed to enforce these things, have no intention of protecting us. It's quite the opposite. I mean, that's been my experience. And until I see a very drastic change, I'm going to continue to think that way. And I suggest you do also, just to be on the safe side. So our show is drawing to a close. I want to thank you for your time. Hopefully you enjoyed the show. Hopefully you enjoyed the content and you learned something from it. Be a good conversation piece. And if this information can help you or someone close to you, then I've done my job for the night. Thank you very much. This is Wally B signing off, Sovereign Mind Show. Once again, brought to you by King Queen Radio of Brooklyn Station. Have a good night. Press the red button, Jay. All right. I finished 8:58.
All right. Yeah, I was like, just that one there stops that.